Oregon Justice Resource Center regarding Senate Bill 819. So let me just start with a couple of housekeeping items. Number one is, if you have not yet, if you were unable to attend part one of this webinar, it is posted on YouTube and on our site. I'll share the location of that. We really recommend that you watch that in addition to this. That part one covered the general overview of the statute, what some concerns are in applying, and today we will be getting more into the nitty-gritty of applying. So please, if you haven't seen part one, make sure that you do after tonight's presentation. Excuse me, my name is Karen Newworth. I'm special counsel to the Fair Law Project at the Oregon Justice Resource Center, and I'm joined tonight by Maggie Powers, staff attorney at the Community Law Division of the Metropolitan Public Defender, and Kenneth Kreuscher, who's the managing attorney of the Oregon Innocence Project. And as I just mentioned, what we're going to do tonight is really try to get into the nitty-gritty of how to apply for SB 819 relief. An overview of what we'll be doing tonight is on the screen now, starting with an introduction. We'll move into best practices and tips for applying. We'll discuss county by county policies, and then we'll focus specifically on Multnomah County's applications. And the reason why we're doing that is one, because we are assuming that many people who will be applying will be in Multnomah County. And two, because the application is very detailed and specific. And so even if you are in a different county, it will offer some guidance for how you might want to structure your application or some of the questions that you want to address in your application, given that many of the county's policies and applications are more open-ended than Multnomah's. And then finally, we hope to have some time for questions and answers. Please feel free to put your questions and answers in the chat box that's labeled Q&A. And we'll address those at the end, unless there's something that needs to be urgently addressed, and then we'll do that. And a reminder that this webinar is being recorded, and so you should bear that in mind. It will be publicly available. So an introduction. I mentioned watching the part one of the webinar. Here is a link to it on YouTube. Here you can find the statute in English and in Spanish. OJRC has put together a fact sheet about SB 819 in English and in Spanish, and you can find it through the links that are on the screen. And then individual DA policies by county with links to those policies is also on our 819 web page. And just as a reminder, if you were unable to attend the first webinar or have forgotten, if you or a loved one is applying for 819 relief, that application goes to the district attorney in the county where the person was sentenced. And so you figure out where the sentencing occurred. That is the county, that is the application, and that is the policy that you'll need to follow. So some best practices and tips wherever you are applying. First is we recommend strongly considering writing a cover letter that puts the whole story together. A cover letter is required by some policies, but even where it's not required, we really recommend it because that allows you to tell the story of why your conviction or sentence no longer serves the interest of justice. What makes your case compelling? Why, if you're incarcerated and making an excessive sentence application, why should you be released? Why should a prosecutor believe that you're a good political bet for them, that agreeing to early release is not going to cause them a political problem down the line? And then how will the world be a better place if you get relief? And I think that thinking about what your narrative is, what the themes are of your application, it should be an important first step, no matter where you're applying or based on what considerations you're seeking relief. Because that way you know the reasons why you believe you're entitled to relief or you should be given relief, and you can collect the documents and put them into your story in a way that makes sense. You need to identify the specific relief you're seeking. In part one, we discussed all of the different types of available relief, but it could be anything from dismissing the charges against you in their entirety, vacating your conviction and immediately releasing you, to shortening your sentence, leaving the conviction as it was, if that's legal, or vacating your conviction and having you plead to a new crime and a lesser sentence.
Hi, Karen.
You need.
Apologies for interrupting. Would you be able to share your screen if we're doing that?
Oh, I'm so sorry. I thought I was.
No worries.
Thank you. Hold on one sec. I'll go back. I apologize, everybody. Can you see that now? Is that sharing now?
It is sharing, yes.
Okay, great, thank you. Okay, so apologies again. Here we are with the links, and again, a PDF of this PowerPoint is in the chat. So if you want to keep this and click on these links later, you'll be able to do so. And best practices. So cover letter, I just walked through, identifying the specific relief, documenting and providing proof of everything. And we're going to talk about both how you find the documents and the proof that you need, and also how you organize that. Please do not put any originals in with your application. Those are important documents, and you want to hang on to them. And then update your application as you get more documents or perhaps have additional bases for granting you relief. Okay, I'm going to turn it over to Maggie Powers now.
Hi, everyone. Again, my name is Maggie. I use they, them pronouns. And like Karen said, I'm a staff attorney at the Community Law Division. I wanted to go over document collection. So a part of your SB819 application is going to be documents. And so some common documents that you might want in your application that you need to collect are as follows. So a police report. So you can request an Oregon State Police report by submitting this form by mail or email. If you click on the link, it'll take you to the form. I would like to point out that requesting a police report, there is, I believe, a $30 fee associated with it. So you do have to pay for it. And it also can take months for the Oregon State Police to fulfill that request. So I would say look at your court documents first and see if the police report is in the court documents before going ahead and requesting it. Other documents that you will want to collect are documents related to your case. And there are two ways that you can get access to these documents. First, you can put in a records request. So each court has their own way to request records, and there's no uniform process. What I usually do is I will Google search the court name and records, and that'll usually take me to a link of how I can access those court records. So I would just put in, for example, Clackamas County Circuit Court records into Google. You can also call the court and ask for records or how to request records. Another way you can do this is you can reach out to your defense attorney. Sometimes defense attorneys will still have these records, and you can request them from your defense attorney. And Other documents that you might want to include or must include, depending on the county that you are applying in, are Department of Corrections records. So if you were incarcerated because of this conviction, you weren't just on probation, but you were incarcerated, you can reach out to the Department of Corrections records to request records such as disciplinary and programming records. You simply email your name, the SID number, and date of birth of the person you want records for to this email address. In the email, specify what type of records you want. So for example, I'm emailing you for my DOC records. Can you please send me my disciplinary and programming records, name, SID number, date of birth? I am not in custody at this time. Disciplinary and programming records are generally free, but sometimes there is a cost associated with requesting these records. And like I said, depending on the county for in which you are applying for, some of the applications require you to include DOC records and others do not require that. So just be aware of that. Next slide, please. Thank you. So a part of your SB819 application, as I stated, is including a record of rehabilitation. What I mean by record is just documents that support your claim. Supporting documents can include character references. So if there are people in your community that can testify to your character, this could be people employers that you've worked for in the past. It could be your neighbors. It could be people in your religious community, such as priests or pastors, but anyone who can testify to your character. When you reach out to a person for a character reference, you don't have to specify what the character reference is for if you do not want to disclose that. You can ask them simply for a generic character reference. Additionally, like I said, you might want to include Department of Corrections or DOC records, a resume, a personal statement, such as, why you should be granted SB819 relief, a little bit about your journey, something like that might be persuasive. Letters from past and current employers, police reports, psych reports and evaluations. And I want to just note that sometimes, or it might be the case that that this application is open to public records. So you need to be careful in providing these records to the district attorney. There might not be information in a psych report that you want to provide to the district attorney, so you might not want to provide a psych report. You might want to include certificates of course completion, such as like for parenting classes or substance abuse treatment or anger management, transcripts and diplomas, job and housing denials, pictures if you'd like, and business reviews. A couple of my past clients have been small business owners, and so they've included Yelp reviews of their businesses. So now let's talk about organizing documents. So you request your documents, you get your character references, and what do you do next? So what I would recommend is to label your exhibits. So as you can see on the left hand image, in the left-hand corner, it's labeled Exhibit 1. I know it's a little small, but you can either do this on a computer or you can just handwrite that. But labeling your exhibits could be really helpful in organizing your documents. And second, if you are choosing to include a cover letter, include a list of documents you are including. So for example, Exhibit 1, Oregon Department of Corrections disciplinary history, and so on and so forth. But it's important to organize your documents so you know what you're providing and the district attorney knows what you're also providing. It might be helpful. Next slide, please. Submitting documents. So submit your documents with the application if possible. So if you are mailing in the application, I would mail in the SB819 application and all your documents in one packet. You can submit the materials by mailing them to the district attorney's office of that county or emailing them to the district attorney's office to the county for which you're applying. I want to point out something that's important for Multnomah County. So in Multnomah County, you can either submit your application by mail, email, or they also have a Google form. However, I want you to know that if you submit your application by Google form, you will not be able to attach documents or a cover letter to that Google form, so you need to send it separately. Thank you.
So my video is unable to be started. Can folks hear me though?
We can hear you, yep.
Okay. Well, hello everyone. My name is Kenneth Krusher. I am the managing attorney for the Oregon Innocence Project. And I will be discussing several sections here at the presentation tonight. The first area that I was asked to talk about was developing evidence. This is a broad area. And I think what's meant here is that when you consider your claims, that is the reason in your petition that you would be eligible for SB819 relief. There may be claims or issues, there may be reasons that you should be available for relief that are outside the documents that would have been developed in your case, or that would be the documents that would have been developed while you were in prison. And those could be varied. So for example, let's say that you were asking for SB819 relief because you were actually innocent of the crime that you've been convicted for. Well, you would want to think about all of the reasons why you're innocent of it, and how you would be able to prove that. And that could be from talking to witnesses of the alleged crime. It could be from talking to alibi witnesses that your trial attorney had never discussed with. It could be varied. If your SB819 reasons, if the reasons for you getting relief in SB819 are something other than innocence, there could still be reasons why you would have witnesses outside of the record. So some of this could be thought of as character witnesses, or some of this could be thought of as people in your family and friends that have seen your behavior in the last years and how you developed. All of those would be situations that you would consider talking to people. Now, when collecting proof of the claims, that can differ based on the type of witness. So for example, if you're collecting character kind of references, or people describing your behaviors in your own family, what you could do, of course, is you could have them write out a statement, and it could be in a letter with their contact information with it. Now, the preferred thing to do would be to create written statements to which a person is swearing under the penalties of perjury, and that would be what, under the law, is referred to as a declaration. Or if it was notarized, it would be referred to as an affidavit. But if it's going to be a friendly witness, somebody that you know is immediately going to be kind of in your corner, a letter with the matter that they're discussing, talking about, whether it's what you've been doing with your life, where you've been working, something to that effect, and their names and contact information would be enough, although sub-ideal, but enough to include in the petition. But the person should know that if they're being named as a witness in the petition, certainly the DA's office, in investigating the petition, you can imagine a DA investigator could reach out and talk to them further. Now, the other situation you have is would especially be present if you were developing claims that would go to innocence, for example, and you'd be speaking to people that you would not automatically know are in your corner. In that situation, there's a couple of caveats to consider. One of them is that you want to be very careful that you're not discussing with them what they should be testifying to, or what information they should be providing, and certainly do not want to try to urge them to change any of their memories or whatnot, because of a concern over what's called witness tampering. The second thing that you want to consider doing is not speaking to them alone, right? So if you were an attorney doing this, you would never speak to a witness without an investigator present. And there's a number of reasons for that I won't go into. But what I would suggest to you is that to the extent that you're talking to people who are not simply friends and family, that you would certainly not want to do that by yourself. And you would want to get a trusted person to go with you and to be able to witness that conversation. Now, in taking statements from the witnesses, what I would suggest is that the best thing to do would be to have any sort of witness write down to you what they're going to tell you in their own words, and either typing it and signing it in their own words, or through their own email. And that's better. It's certainly preferable than you summarizing what they're going to say to you. Now, I realize that in some situations that may not be possible, but that's definitely the preferred manner. Once again, though, the thing that you want to be cautious doing, very cautious doing, is suggesting to anybody what you want them to say, or trying to get them to change what they otherwise would have said. Because once again, you want to avoid any possibility of witness tampering. Now, I will also note this, is that if your claims for SB819 are highly dependent on developing witnesses or evidence outside the record, it's in this situation that you may really want to consider trying extra hard to find a lawyer with an investigator to assist you.
Thanks, Kenneth. Excuse me.
And there's certainly a lot more to be said about the question of developing evidence. I guess the last thing I'll say about it is I would think about writing down all of the reasons that you're asking for SB819 and think about the facts and pieces of information that you would like to be included in the petition to support each of those reasons. And on some level, you'd want to think about how you're going to prove each factual assertion that you're making.
Great, thank you. So I'm gonna talk now again about the county by county policies. And so as a reminder, on the OJRC 819 website, you can click through to a spreadsheet that summarizes all of the policies by county and allows you to click through and read those policies. And again, this is for your application has to go to the district attorney in the county where you were sentenced. So I'm going to spend a few minutes going broadly over the policies, describing the policies in the different counties, and then we're going to turn to Multnomah. So several policies have several counties have no policy whatsoever. Those are Curry, Douglas, Gilliam, Harney, Jefferson, Lincoln, Morrow, Polk, Sherman, Tillamook, Umatilla, and Yamhill. And I apologize if I got any of those pronunciations wrong. I'm not from Oregon. But those counties do not have policies. That does not mean you can't apply, but it just means that we don't know. They have not revealed to the public yet what their priorities are, what they will or won't consider. So if you're in any of those counties, you should, think about, well, if I'm eligible under the statute, do I want to apply? Are there risks and benefits to applying? We discussed at length in part 1 the risks that can be associated with applying. And again, I encourage you to review that. Lynn and Union counties have no publicized policy. They do have an application which provides some guidance in how to apply. OJRC is in touch with all of the counties. Those that don't have policies, we're asking that they either create a policy or publish one if they have one internally, so that folks can have guidance. And we will be updating our resource website if we get additional information. The next group of policies are what we would call the more liberal policies. Those policies generally say that they will consider all statutorily eligible convictions that are not currently on direct appeal. So again, part 1 goes through who would be eligible or what convictions are eligible under the statute. But in short, it's felonies that are not aggravated murder and that are not presently eligible for expunction. These counties that have the more liberal policies generally say something to the effect that convictions for sex abuse, domestic violence, or a crime involving a child as a victim will be approved for submission only in rare circumstances. So the counties that have these policies are Wasco, Deschutes, Malheur, Clatsop, Klamath, Clackamas, Benton, Baker, Crook, and Hood River. Benton, Clatsop, Crook, and Hood River have a few additional limitations. Their policies state that the relief sought can't violate any victim rights law, and that the only applications that are completely filled out and accompanied by a cover letter will be considered. Clackamas policy says that an applicant will be ineligible if they have not yet served at least 50% of the imposed sentence, if any victim restitution is owed, if there was a conviction for a subsequent crime, or there are pending charges anywhere in any court, if the sentence was to probation, that probation was not successfully completed or was revoked, and or if an 819 application was put in and denied in the last 36 months. So those are the more liberal counties. You should go on your county website and very carefully read the policy and also look at the application. Most of the applications from these counties are fairly open-ended. And so even if you're applying in one of these, I would recommend that you stay on for the discussion of Multnomah County application, because it will give you some ideas about how to put together your application there. The more restrictive policies are essentially leave very little room for 819 relief. They generally say, absent extraordinary circumstances, which include newly identified evidence that significantly calls into question the integrity of the evidence that formed the basis for the original conviction, the following cases will not be reviewed. Any level of homicide, any violent sexual offense, any sexual offense involving the abuse, solicitation, or unlawful depictions of a child, any violent felony conviction where an applicant has an extensive violent criminal history, where incarceration was imposed after a person was found to have violated probation on a downward dispositional departure, cases where there was already a benefit from a significant reduction in charges as a product of negotiations, so in the course of a plea agreement or plea negotiations, cases where the defendant has not already served at least 50% of the original imposed sentence, and cases involving enhancements for firearms and use of deadly weapons. So those really capture the vast majority of felonies. It is certainly possible that a person wouldn't fall into those categories, but if you're in the counties with the more restrictive policies, chances are, and I'll show you which counties those are in a moment, chances are there's not going to be a lot of, a high likelihood of success. Other considerations under these policies for denying resentencing review, that the original sentence is appropriate under the current sentencing laws, strong opposition from a crime victim, a request for the same relief was denied in the past 24 months, the applicant has an open appeal or post-conviction petition filed, and a court would be required to impose the same sentence, such as if a mandatory minimum was required to be imposed. And the counties that have these policies are Wheeler, Lane, Lake, Josephine, Marion, Grant, Washington, Jackson, and Coos. Washington and Jackson clarify that under the same considerations, applications will be rarely considered, and Coos also adds that folks who have multiple sentences with multiple victims will be ineligible. So Multnomah and Columbia counties share the structure of how they consider applications, and that is they've divided SB819 applications into three categories: actual innocence, collateral consequence, or excessive sentence. Actual innocence basically means you were wrongfully convicted because you did not commit the crime for which you were accused. In other words, you are factually innocent, a traditional innocence claim. Collateral consequence claims are that your conviction has had or is having an undue and extraordinarily unfair impact on other aspects of your life. So for example, your ability to get a housing, to find employment, or fully participate in your child's life is being affected by your conviction. So collateral consequence claims are made by people who are not incarcerated. Actual innocence claims may be made by folks who are either in or out. And then excessive sentence claims are claims where the person would say, yes, I am guilty of the crime for which that I was convicted of, but I've been disproportionately punished for the crime, or the punishment no longer serves the interest of justice. And those claims are for people who are incarcerated. Each category has its own application in Multnomah and Columbia counties. Columbia County's application is more of an open-ended application with just broad questions that ask for long narrative answers, whereas, as you'll see in a moment, Multnomah's application is far more detailed with both multiple choice questions and short answer and longer answer questions. Accessing the application. So this is a screenshot of the Multnomah County DA's website, the Justice Integrity Unit, and there's a link down there in the bottom left-hand corner, and you can see in that right-hand bar, the third bullet down says for SB819 applicants. And when you click on that, it will take you to each of the three applications. So each of the three Multnomah applications share a number of questions, and I'm going to go through those in a moment. But I wanted to go through the Multnomah specific definitions of each type of application. So an actual innocence application requires that the Justice Integrity Unit be able to identify one or more avenue of investigation that has the potential to substantiate your claim of innocence. So I'm innocent, and I'm innocent because this was committed by X person. So there could be an avenue of an investigation into X person. Or my alibi is Y, and there's an avenue of investigation where the JIU could substantiate the fact that you were out of state at the time that the crime occurred. The applicant cannot have committed another criminal offense within the last 36 months and does not have any pending charges in any jurisdiction. That's federal or state, within or outside of Oregon. The applicant is willing to cooperate fully with law enforcement to identify and bring to justice the person who actually committed the crime. Collateral consequence applications require that the conviction did not involve domestic violence unless it was a domestic violence conviction that occurred when the applicant was a juvenile. The applicant has not applied for and been denied SB819 relief within the last 36 months. The applicant has not committed another criminal offense within the last 36 months and does not have any pending charges. The applicant demonstrates substantial rehabilitation and presents a low risk for further criminality. And the applicant demonstrates that their conviction causes manifest and particularized hardship. And finally, excessive sentence. And this is the most complicated one as far as figuring out if you're eligible. But again, you must be incarcerated. You cannot owe outstanding victim restitution. You must be willing to admit guilt. Your sentence cannot have been part of a global settlement with multiple counties. And that's from Multnomah's point of view. That's not a requirement that we've seen in other counties. The applicant has not committed another criminal offense within the last 36 months and no pending charges, and no application for 819 relief in the last 36 months. And then one of the following has to be true. Sentenced as a juvenile with a term of incarceration remaining, the person is approaching age 25 and will be transferred to adult prison. The applicant committed the crime when they were under 18. The applicant is over the age of 60 or has a terminal or debilitating illness or is in hospice. If the conviction was for a non-person crime, the sentence must be longer than 10 years in total. Or if it was a person crime, the sentence or sentences must be longer than 16 years in total. So those are the application requirements in Multnomah by category, and we'll look at some of the shared questions, not all of them. So the application begins with a number of kind of background questions, who the person is, and so on. And I just wanted to highlight here question 2.3. If you're asking someone else to fill this out, you must indicate that you consent to them filling out the application. So that's very important and not to be overlooked. These then are the important notifications that are part of all the applications. And these notifications basically speak to the concerns that we discussed in part one, the risks that are associated with applying for 819 relief. So that first caution is, as Maggie mentioned a little while ago, that everything that you put into your application, including exhibits, is subject to release under the public records law. So somebody, any member of the public, could ask to see your or anybody else's 819 application, and everything that you put in that's not otherwise subject to redaction can be released. So that's really an important consideration, whether it's as what you say occurred or didn't occur, or any of your exhibits, your personal private medical information, the letters from people who have known you, perhaps if you have a history of being the victim of abuse or having a substance abuse or substance use disorder that you wouldn't want to be a matter of public record. You should bear all of that in mind, both in terms of deciding whether to apply at all and what to include. The second caution is that applying for 819 relief does not toll or stop the statute of limitations from running on other potential judicial avenues for relief. So if there's a statute of limitations to file an appeal or to file for post-conviction relief, you need to do those things without regard to whether or not you apply for 819 relief. And as you'll see, most policies will not consider 819 relief for anyone who has a direct appeal pending, and some of the policies won't consider an 819 application if there's any matter pending relating to the conviction, post-conviction, direct appeal, or otherwise. So again, you'll need to make some difficult decisions about what relief to pursue. And that's, something that should be discussed with an attorney familiar with your case. Third, that you're dealing with a prosecutor's office on the other side. They cannot provide you legal advice. They are not your counsel. They're not defense lawyers. And so although you are likely to be unrepresented, this is an adversarial process, and that should be borne in mind at all times. You need to affirm that your statements are provided voluntarily. The next two cautions have to do with the negative consequences that could potentially flow to you. And we discussed these at length in part one from applying. One is that you may make an admission about something that you were involved with or someone you care for is involved with that might require the office to make, to report mandatorily or to make Brady disclosures. And also that there could be negative consequences to you if you have made a misrepresentation in the application. And then those cautions go on to just require you to affirm that no promises have been made, you're doing this voluntarily, that they're under no obligation to review or grant you relief, and that this is a purely discretionary process. Other important notifications here at 3.3. These statements are optional, and what is occurring here in 3.3 is Multnomah County is asking whether or not you would give your former lawyers or innocence organizations that you've worked with, if any, permission to share the work product that they created on your behalf. We're not in a position to provide legal advice, but waiving the attorney-client privilege, if you have it with a prior lawyer or with an innocence organization, would be a very dramatic step. And you will certainly have the opportunity to make that decision down the road if you know that the district attorney's office is considering your application. But I would be quite concerned about a waiver of that privilege just out of the gate. And so that's with respect to the first two statements. The third is giving the JIU permission to share information from their review of your case with any local innocence project or other innocence organization or law clinic related to innocence work. That is far less concerning because, as we have already discussed, whatever you share in your application is already a matter of public record. So there is not the same concerns attendant with that. Then questions 4.1 to 4.16 ask a number of general applicant and case information questions. You need to be as accurate as possible. So again, Maggie discussed how to get your case files, and then you just need to basically look at your case file and make sure you're accurately putting down all the information, whether it's case number, the court, or the judge who sentenced you. And then, of course, be very careful that you've got the age at the time of crime and your conviction accurate, because as we just saw, that may form a basis of relief. Questions 5.1 to 5.7 ask for the names of all of your attorneys, anyone who represented you on the case that you're trying to get relief from. Asks whether or not your case was resolved by a plea. That's, of course, you didn't go to trial, you took a plea deal, you entered a plea of guilty before a judge. A bench trial, which is a trial before a judge, there was no jury, but both sides presented evidence, and at the end you were convicted. versus a jury trial, which is of course a trial with a jury, and then if you had a non-unanimous verdict. And again, this is also very important to get that right if you did have a non-unanimous jury verdict. The next group of questions ask about whether or not you have any active appeals or post-conviction motions and to identify them. And again, if you do have an active, meaning a pending direct appeal. So a direct appeal has been filed and no, the decision has not yet been rendered on that, is probably going to make you ineligible in most counties. And then it asks about prior post-conviction motions. Questions 5.8 to 5.12 are more questions about the evidence in your case and specifically DNA. 5.8, was DNA evidence used in your case? So be careful, this is a very specific question, right? This isn't just, was there any physical evidence, but specifically was DNA evidence offered in your case? And so normally you probably would have had an expert or a lab technician, you or the state would have had someone who would specifically testify about that evidence. And then 5.9 asks who put that evidence in. So generally speaking, if the evidence pointed towards your guilt, it would have come in from the state. If it pointed towards your innocence, it's likely it came in from the defense. It is fine if you don't know. And of course, if you didn't have a trial or there was no DNA evidence in your case, you would mark those. And then the next questions ask whether or not you've since filed a motion for DNA testing under state law, whether it was granted and if DNA testing was done. Next, 5.13 through 15 is asking about your contacts with local innocence organizations or law clinics. Again, there are some concerns about these questions because your communications with an innocence organization or law clinic might be privileged. And so you may want to think about, whether or not answering these questions might require you to expose information that you don't want to do and whether or not that would change your perspective on applying. The application asks which organization and when, and whether or not they are currently investigating. And you may not know the answer to those questions, or it may be inapplicable. 5.16 to 5.23 asks about your prior clemency petitions and expungement applications, if any. And just a reminder, we discussed at length the relationship between expungement and 819 relief. But if you are currently eligible for expungement, you are statutorily ineligible for SB 819 relief. So again, please watch the first training video and pay careful attention to the discussion of what crimes are eligible for expungement. And if the required time periods have passed and all the other qualifications for expungement are met, then that is the route that you need to take. You're not eligible for 819. Kenneth is going to discuss the actual innocence application now.
Great, can folks hear me? So so actual innocence. So what is an innocence claim and what is it not? An innocence claim would be a claim or an argument that you are innocent, that is, you did not commit the crime that you are convicted of, or that you were charged with. And the way that this is oftentimes looked at by innocence organizations, such as the Oregon Innocence Project or the Innocence Project, and it's been essentially adopted by the terminology used in the application is there an avenue towards an avenue or a path to innocence in the case? And those paths or avenues to innocence can be a number of things, but there's some that are most common. So for example, was there forensic evidence, oftentimes DNA, but also it could be, fingerprints, matching evidence. Was there forensic evidence that was used to convict you that was bad at the time. And you can think about that, i.e., was there DNA evidence that was used in your case, and does it just not make any sense because you weren't there, right? So that could present a path to innocence, for example, because if you were convicted 15 years ago, 20 years ago, and DNA evidence, an earlier state of the science of DNA evidence was used to convict you, well, there's a good chance that if we got, and that just doesn't factually make any sense to you, because that you weren't there, or that you didn't handle that item, or whatnot. That you are innocent of the crimes charged, and yet there's DNA evidence used against you, and your case is old. In cases like that, a new look into the DNA evidence can produce some good results that can provide a path to innocence. That is, it can provide some sort of evidence of an objective fact that you can prove in a case that can show that you couldn't have possibly been guilty of the crime that you were charged with. So another other paths to innocence include false confessions, right? You could look back at your case and you could think, okay, under pressure from questioning and interrogation by law enforcement, I provided a confession, but I know it was a false confession because I know that I actually did not commit it, but I confessed, and I may not understand why I confessed. Well, you should just know that false confessions happen, and if it'd be kind of too strong to say that they're common, but they're common enough that they present one of the main paths to innocence in cases of exonerations and in cases in which people have actually been exonerated and they've been able to prove their innocence. So you could also look at it, and if your case, because you know that you didn't actually commit the crime that you were convicted of, but you'd given a confession, you can look at that and try to think to yourself, how did that come to be? Where did that confession come from? And you could talk to the DA's office and the SB819 petition about that, and that could provide a place for them to investigate to show that the confession was clearly false. Another way that you could say in your case, because you know that you didn't actually commit the crime and you know that you're innocent, but you had a trial or you saw a police report in a case where maybe you pled guilty, and you know that one of the state's main witnesses was lying, right? Had provided a false statement. So either that could be a false identification of you, saying that you were there, or saying that something happened when it didn't happen, and you think that that statement played a great part of the state's case. You can identify that as a potential path to innocence, in which you can prove that you're innocent if you're able to undermine that central testimony, that central narrative from a state's witness, whether that be a jailhouse informant, or whether that be a witness who's saying they're actually a witness to the crime, or somebody who said they identified you in a certain situation. So that also could provide a path to innocence. Of course, another one, a classic one, would be an alibi. If you would say that you were actually somewhere else at the time of the charged crime, and you know that you could not have been there, but your attorney didn't listen to you, or something to that effect, that would be another path. Essentially, what you want to do is you want to try to think about some way that you'd actually be able to prove your innocence in the path to getting there. Now, I will note right now that, at least with Multnomah County, part of what they require is that if you are actually innocent, they would essentially require you to cooperate with the state in trying to find the person who actually committed the crime. So, that could be that you would be state's witness or state's evidence against another person, or that you would at least debrief with law enforcement and tell them everything that you know about the situation possible. Next slide, please. So there's a particular, there is a particular kind of sub-application or section to an application in Multnomah County when you're actually proving innocence or you're claiming innocence. And essentially what they're doing is they're going through those different paths to innocence and they're trying to get you to help them and to identify to them kind of which path that is. And you can just kind of see down right here, 6.1 is not really that important for our purposes. It more goes to whether or not Multnomah County is going to spend their time and energy on it. In general, they're not going to spend their time and energy if the convictions weren't in Multnomah County. They're statutorily barred. The legislature has chosen to not allow SB819 relief to be available for ag murder cases and felony and with felony convictions. Which I believe that's also a statutory requirement, or at least it's certainly something that Multnomah County is dealing with. I believe it's also a statutory requirement. Hopefully, one of the other panelists will affirm that or
yes, it is. It is. Those three questions are making sure that you're eligible for 819 relief.
Perfect. And then other than that, so 6.2 is they're going through for their own kind of data collection purposes and for them to highlight what to look for is it can be a number of different possibilities of different types of claims for actual innocence that have been in other cases. So for example, one of the areas that I kind of skipped over, although I briefly referred to, is that if there was a statement that was used against you that was core to the state's case, which could be the so-called victim of your case saying that you had committed the crime against her or him. Later on, what happens sometimes is a recantation takes place and the victim actually comes and maybe they get older if it's a sex case or something to that extent, to that effect, and they say, oh, actually I had lied and I was mistaken, and actually the person, meaning you had not actually committed that crime. And so that would be recantation. Essentially, you can look through 6.2 and it'll talk about some of the various paths to innocence. So alibi, was there a bad confession? Did you feel like your confession was coerced? Was there DNA evidence in the case? When it talks about hair comparison, because in general, some of the science, some of the evidence that has been used by the prosecution, which is oftentimes matching kind of forensic science, where they're saying, oh, these cuts came from this bolt cutter, or these hairs match other hairs, or blood spatter. There's been some development in forensic science that has cast some of that science and some of that evidence in a bad light. And there's some ways now that we can get forensic scientists to come in and look and say that the state's science 15, 20 years ago is unreliable. 6.3 then also talks about eyewitnesses. Kind of 6.4 through 6.7 are sections where you can kind of expand upon the particular explanations and particular kind of claims that you have for actual innocence. I would suggest that you not feel limited to these 5 or 6 lines, and that instead, if you feel the need to expand or to describe more clearly kind of what that path to actual innocence is, or what the explanation for what new evidence would exist, or what path or avenue of investigation to that path to innocence would exist, that you take the time and that you clearly explain everything you can in a way that would assist a person that wanted to investigate your innocence claim into looking at it. Now, again, and Karen talked about this, and I'll just refer again, is that there are some dangers with the SB819 case or procedure, in which what you're dealing with is you're no longer dealing with somebody such as an innocence organization, which is going to keep their investigation and your statements confidential and privileged, and is playing kind of an advocacy role where they're kind of working on your side. Instead, with the DA's office, you're essentially giving them information that they may or may not decide to use against you in further in a further prosecution, for example. So so there are some dangers there. We can go next. And then essentially it just continues with them providing you places for you to further provide information to the DA's office to describe why you are innocent, and to further provide them with information describing what that path of innocence is. So, one of the areas that that is highly present in a lot of innocence claims is, once again, where there was forensic evidence that would have falsely kind of targeted you or falsely fingered you as the person who had committed the crime. If that forensic information can be disproven, sometimes it can actually be shown that it was somebody else that committed the crime and that you would have been excluded. And if that forensic evidence or forensic science actually excludes you from potentially committing the crime, well, that's a good basis for innocence. So as you're going down into 7.1, it's where they ask you to talk about, is this an innocence claim? Is this an excessive sentence claim or collateral consequence claim? We'll talk about that more. Now, if you are unable to say that, I will just note, and we'll talk about it more, that with the excessive sentencing claims are kind of incompatible with innocence claims, because with innocence claims, what you're saying is I am not actually guilty of the crimes that I was accused of. And then with excessive sentencing claims, what they want you to do is they want you to admit guilt and say, yes, you are guilty of those crimes, but the sentence is excessive for a variety of reasons. So in some ways with innocence claims, you could be in a situation where you could say, you could say that you are innocent of part of the crime, even if you were guilty of some of the crime, and you could sort of argue for an excessive sentencing relief under SB819 under that basis. For example, if it had been in a situation, you could, argue that you did not actually commit the full crimes they said you did, but that you had lesser culpability for a variety of reasons. In going through the innocence claim, once again, what they're doing is they're just trying to get you to provide them more information that they can look at the path, and folks can read through the questions and kind of answer them as they go. Those questions refer not only to kind of the reasons why you had not actually committed the crime, or why the prosecution's case was unreliable against you, but also provides them with further information that they can use as context in investigating. So that includes information such as what else you were doing that day, how exactly you came to be arrested, or I also think how you came to be kind of targeted by them, to provide them with an idea about that. And then they're just asking you for further information. Now, the thing that you want to think about, though, I think the thing that's most useful here in thinking about the innocence claims is, once again, for you to try to identify what you think went wrong with your trial and how it happened that you ended up being convicted of the crime that you were actually innocent of. And reflecting on that and thinking of all the reasons, there could be multiple ones, will provide you with a starting basis for you to think about what sort of information and what sort of evidence would be needed to show your innocence.
Thank you, Kenneth.
I'm going to talk about collateral consequence claims in Multnomah County. So you will fill out the collateral consequence application in Multnomah County if you have a non-expungible felony conviction and you have fully completed your sentence, including all post-prison supervision or probation, and there's a manifest and particularized hardship associated with your conviction, and that you are substantially rehabilitated and present low risk for future criminality. In the next couple slides, I'll dive a little bit deeper into what those phrases mean. And in a collateral consequence application, you basically request relief in the form of getting your conviction off your record or modifying your conviction in some way, such as vacating the judgment or reducing the conviction to an expungible conviction. So what is a manifest and particularized hardship? So basically, ask yourself, what are the barriers you are facing because of the felony on your record? In my work, the most common issues are a person is unable to secure housing, or a person is unable to secure employment because of the felony on their record. This can also impact an individual's ability to volunteer at their child's school. An Oregon statute requires volunteers to undergo a background check. And there are certain quote unquote forever crimes that if you are convicted of, many of which are non-expungible felony convictions, you are unable to volunteer at a school in Oregon. Lastly, another manifest and particular hardship might be just living with the stigma of having a felony. That could rise to the level as well. So these are just a few examples. What is substantial rehabilitation and low risk for future criminality? So basically, in an application, you have to demonstrate that you are quote unquote substantially rehabilitated. This includes completion or participation in the courses of treatment, such as substance abuse, mental health, anger management, and other treatment, full payment of financial obligations, rigorous compliance with court-ordered conditions, evidence of pro-social community involvement, volunteer work, evidence of stable employment, academic or professional certifications, and no subsequent criminal convictions. So I'm going to walk through the collateral consequence specific questions, which are questions 10.1 to 10.14. So on the PDF application, these are pages 14 through 17. So first we have question 10.1, if we can flip to the next slide. Similar to the innocence application Kenneth went over, the first question just basically you need to check the boxes. So hopefully these 5 sentences apply to you. Basically, I am not currently incarcerated and have completed all terms of supervision. My convictions are not registrable sex offenses and did not involve domestic violence. That's Multnomah County specific. The third one, I believe that I have completed substantial rehabilitation. Number 4, I believe that I present a low risk for future criminality. And 5, I believe my conviction causes manifest and particular hardship for me. So hopefully all 5 of these apply to you. Basically, the district attorney is just trying to make sure that you're eligible for this relief. Question 10.2 goes to the particularized hardships that you're experiencing. So again, ask yourself, what hardships are you facing or have faced because of the felony conviction? Think about jobs, housing, stigma. And so in the application, be as specific as possible. So for example, because of this felony conviction, I'm having a hard time getting a job. For example, when I applied to be a Lyft driver in March 2022, I was denied because of my criminal record. And possibly, hopefully, you can put in a denial letter showing that you have been denied a job. But what I want you to take away is be as specific as possible in answering this question. Question 10.3 asks you to briefly and accurately explain the events surrounding your offense. If your version differs from the official version of the events, you must give the official version before explaining the way in which your view differs. The Multnomah County application does not define what the official version is. What I have come to the conclusion is that it's probably like the police report or the indictment. And I understand that, you know, the police report may include inaccurate facts about the situation, and that can be frustrating or re-traumatizing. So my suggestion is that in answering question 10.3 is you have one paragraph that summarizes the official version, and then you have another paragraph summarizing the way that you experienced the incident. So again, first explain the official version and then give your version of the events. Question 10.4 says, explain any challenging circumstances you dealt with leading to your conviction. For example, substance use, domestic violence, mental health challenges. Basically, this question is asking you, what did your life look at the time of the incident? Were you struggling with substance abuse or a mental health crisis? Were you the victim of domestic violence at the time? Again, disclose only the information you are comfortable with. Sometimes, especially when the conviction happens between the ages of 18 to 25, maybe your home life or circumstances in which you grew up matters. So include that to your comfort level. Question 10.5 reads, describe your family situation and responsibilities, indicating whether you are single, married, or divorced, and whether you have dependent children or other people for whom you are financially responsible. Please also tell us about non-traditional family members or relationships. Basically, this question breaks down into 4 questions. So who lives in your household? Who are you financially responsible for? How many children do you have? And are you married or single? Question 10.6 reads, describe any courses of treatment, including substance abuse, mental health, anger management, or other treatment that you have engaged in since you were convicted. So for example, if you engaged in substance abuse treatment, be as specific as possible. If you did inpatient treatment, when and where? If you did outpatient treatment, when and where? And hopefully in your document section, you have either certificate of completion or a letter from the provider stating, you know, you've done these treatments. Again, you want documents to back up what you are writing about in answering these questions. You can switch to the next slide. Question 10.7 states, describe any academic accomplishments or professional certifications you have obtained since being convicted. Describe how your conviction has affected your efforts. So this could be high school, college, vocational training, educational, professional training while incarcerated. And again, request like transcripts or diplomas and include that in your document section. Questions 10.8, 10.9, and 10.10, I call the employment questions. Basically, they want to know your employment before or after your conviction. So for every job you've held, include, you know, when, where, and for how long, what your job responsibilities were, and why you left the job. Some folks don't have any like notable employment before their conviction. That's okay. You just need to make a note of it when you're answering these questions. And for some individuals, their employment was being a stay-at-home parent or a full-time caretaker. That's okay. Just note it while answering these questions. They also want to know about your future employment goals. So talk about if there's like a career path that you want to pursue or a career that you aspire to. And then talk about any barriers that you face. In the document section, include a resume if you have one. Question 10.11 says, tell about your involvement with any public service or community activities. List any special accomplishments. So here they want to hear about your volunteer work, community activities, or other public service. Again, be as specific as possible. And in the document section, hopefully you can get a letter from the organization you volunteered for, just stipulating, again, where, when, and for how long you volunteered and what your responsibilities are for. You can also include in this section any future volunteer work you're going to engage in. Question 10.12. It states, describe your criminal record since your conviction. So if you are applying for relief for a non-expungible felony, and then after that conviction, you have other convictions or arrests, I highly encourage you to disclose it in this section. And go through each conviction or arrest and describe the incident and include any mitigating circumstances. Basically here, this is your area to explain your side of the story. So, tell them why you have a subsequent conviction or arrest. And if you are expunging other eligible offenses, make a note of that. Question 10.13 states, list any debts you owe, including restitution, and how you plan to pay them. If you have paid restitution associated with your case, tell us about it. In order to find out, I would call the court and ask. I would ask them, do I owe any money on this conviction? And does that include any restitution? Restitution is basically money that's owed to a victim, and the victim can be a person or like a corporation, like a business. Question 10.14 asks for character references. In Multnomah County, it says, do not list relatives. So other character references could be employers or other community members. Again, it states, if possible, these individuals should be aware of your crime. Whether they know about the crime or not, they must be familiar with your present circumstances and activities. So in this section, I would list the character reference name and their contact information, so that if the DA wants to reach out to them, they can reach out to them. So basically, I want you to have these 3 takeaways from the collateral consequence application. So again, Karen talked about how there's 3 different types of applications, or Multnomah County and Columbia County have broken them up into basically 3 claims. So you are going to be submitting a collateral consequence claim if you have a non-expungible felony conviction, have completed your sentence, including post-prison supervision and probation, are experiencing a manifest hardship because of the conviction, are substantially rehabilitated and present a low risk for future criminality, and meet any other county-specific requirements. Second, build a strong record of rehabilitation. So when you're answering the questions in 10.1 to 10.14, have a document supporting everything that you're saying, or try to. And lastly, disclose the information to your comfort level. So don't disclose anything that you're uncomfortable disclosing with. And lastly, if you want to reach out to me with more specific questions or anything that I didn't cover, my preferred method of communication is email. But I understand that some people don't have access to email, or that's difficult. So you can always give me a call. My direct work number is stated here. And lastly, if you'd like, you can call our intake number at the Community Law Division and see if you qualify for our legal services, which include help with an SB819 collateral consequence application.
Great, thank you, Maggie. Okay, I'm going to talk now about the excessive sentence application. So the excessive sentence application includes many of the questions that Maggie just talked about. So there is a slightly different context in your answering them, but they're asking for the same information. So I'll start with the key points for an excessive sentence application. In some ways, excessive sentence applications are the riskiest applications from the prosecution's perspective. Unlike a collateral consequence application where the person is already out in the community, excessive sentence applications are asking for relief from incarceration. You're asking to release me now. And unlike an innocence application, you're saying, and I'm guilty. So this is going to be, and I think one of the questions that was posed in the Q&A brought this up, where we're living in a moment right now where the pendulum has swung back, and prosecutors are very sensitive to allegations that they're soft on crime, or feeding into the news narrative of increased crime, and people are fearful. So when you are doing an excessive sentencing application, you must be mindful that from the prosecution's perspective, their main concerns are, why should I take a chance on you? Why should I agree to release you early from prison when you acknowledge that you are guilty of this crime? So it's really important, perhaps most important in this application, to have a really clear narrative about why your sentence no longer serves the interest of justice, and why, what evidence you have to support that narrative. So some examples of a strong theme would be, my circumstances have changed, and here's how, right? So I was suffering from substance use disorder at the time of the crime, and I committed the crimes because I was high, or because my addiction required me to do things that I wouldn't ordinarily do, or caused me, to do those things. Another explanation is, I was young and a juvenile, and there's all this research that shows that juvenile brains are not completely formed, and so I couldn't really appreciate the consequences of my actions. Or I've spent so much time in prison that I've been on a journey of self-improvement, or I've become religious, or any number of things that demonstrate a change from the person who committed the crime to the person you are today. And that I will not reoffend. And how do I establish I will not reoffend? All of those pro-social things that Maggie just went through. I am active in community service, even on the inside. I participate in, I have pursued my education to the extent possible. And then you also need to explain why your continued incarceration no longer serves justice. And that might be that your continued incarceration is either harmful to you and or others. And so think about the people in your family and in your community who are harmed by your continued absence and your inability to be a productive member of society outside of prison walls. Another example of a theme is, my crime was totally out of character. Everything that in my life prior to the crime and since shows my true character, which is inconsistent with whatever happened on the day in question. And my continued incarceration no longer serves justice. It's harmful to me and or to others. So again, as with perhaps more even than in the collateral consequence application, your record of rehabilitation is critical, and it must be well supported. And for folks, we don't really have the time today, and if there's interest, we can talk more about the specific challenges of obtaining documents for people who are incarcerated. But probably the best way to get documents are through the methods that Maggie discussed earlier, with somebody on the outside, or through a counselor who's willing to help. But the record of rehabilitation is critical. Somebody asked in the chat about whether or not every program comes with a signed document stating that it was completed. The advice is, whether or not that's offered to you, you should ask for some documentation of every step you take towards your rehabilitation. And so I know that there may be people who are watching who are not ready today or this year or even in the next 3 or 5 years to complete an SB819 application, but you should be thinking that if at some point in the future you're going to apply for 819 relief, you need to start building your evidence now. Getting records, documenting everything you do. Somebody that I spoke to who successfully got 819 relief described how during his incarceration, he kept detailed handwritten records. On this day, I did this program. On this day, I took this class. And so he had his own records plus the certificates. And then the third thing for an excessive sentence application is you must have a detailed, clear, concrete, and well-supported release plan. Because again, these are going to be the most politically tricky applications for district attorneys. And what will make maybe a skeptical prosecutor feel more secure in granting your request for relief is knowing that you are going home to a welcoming family or community, to a program that's in place to keep you safe, healthy, and productive in society. So we'll look quickly at some of these questions because I know our time is very short. So the application starts again with a series of questions that go to eligibility, and we've discussed that. So you just need to read those carefully, check the correct ones that apply, and make sure that you are in the right place and you are indeed eligible. These are similar to prior applications and have many of the same questions that you just heard about. So here are more of the eligibility questions, just so you can see they do here true and not true, and then something applies or does not apply. And so you need to be currently incarcerated, have served at least 5 years, and not be part of a global plea agreement. So you need those first three questions in 9.1 to be true. And then you need at least one of the following in 9.2 to apply to you in order to be eligible. Briefly and accurately explain the events surrounding your offense. If it differs from the official version, give the official version before explaining the way in which your view differs. So again, this would be an opportunity in the excessive sentence context to explain why your sentence was either excessive when it was imposed or is now excessive in that it no longer serves the interest of justice. So perhaps the official rendition of the events has you being far more culpable in the crime than you actually were. And that would be a reason why your sentence was excessive. Or perhaps the official rendition of the crime doesn't acknowledge that the person who was your co-defendant was also your abuser, and that would be information that would be relevant and go to why you committed the crime and why you should be punished less severely. These are just examples, but those would be ways in which you would want to highlight the distinction. Questions 9.4 to 9.9 are the same as for collateral consequences. What were the challenging circumstances? What is your family situation? What did you do for work prior? What have you done for work while you've been in custody? What are you planning to do in the future, and what public service? So the difference between this application and the collateral consequences is that you want to emphasize why any of these facts would go to your narrative. So again, if it's things have changed, it's, you know, all of the challenging circumstances. I was in the throes of a horrendous drug addiction, and that was a really challenging circumstance that led to my conviction. I've now been in recovery. Here's all the proof of the activities I've done to get into recovery and stay in recovery, and here's the proof. And since that was what caused me to engage in the crime that I was convicted of, I'm not going to do it again. And then also when you're talking about your family and the people, you know, whether they're blood relatives or non-traditional family members, how you're being incarcerated negatively affects them. And think in particular about children or minors, elderly people, ill people, the ways in which you would contribute to your household, either financially or by being a caregiver if you weren't incarcerated, and how that would benefit the people in your family. And likewise, if you have done community service, been a mentor to people on the inside, how you might continue that productive pro-social work on the outside. Questions 9, 10, and 9, 11 describe your past criminal record and your disciplinary history. So again, you've got to, if it's, if you have extensive past records, you've got to own everything in your record. This is not a time to try to, split hairs about, well, that wasn't really, that was inaccurate. I didn't really, you've got to describe these things in the context of your story. So if the story is, I'm a changed person, all of those things that occurred before are in the person who committed the crime, not the person who's seeking release now. And if you have no prior criminal history and you've got a good or impeccable disciplinary history in prison, that would support this narrative of the crime that I got convicted of was really a one-off, and all of my other, life shows you the person that I will be if you cut my sentence or release me now. 9.12, list any debts you owe and how you plan to pay them. So again, this was covered in the collateral consequences section. But I think that you can tie this into the relief you're seeking, and the fact that getting out would allow you to get meaningful and or well-paying work that would allow you to deal with these debts that you might owe. And I would just say for folks for whom debt and particularly victim restitution might be an issue, though there are other additional thoughts, and if there's interest in hearing that, that may be a topic for a future training. Release plan, I mentioned this earlier, probably the most critical part of an excessive sentence application. You need to be detailed, clear, concrete, and well supported in your plan. So you want to think through even the seemingly minor details. Like if you say, I'm going to live here with this person, and I'm going to, I anticipate that I will be able to get a job here, maybe because somebody, you worked for previously is willing to rehire you. Well, where's the money going to come from until you get your first check? How are you going to get from home to the job before you're getting your check? What is somebody willing to provide you with financial support for a period of time while you look for employment if you're not coming out with a plan for a job? You can include with your application letters from those who plan to support you and how. So if somebody is willing to let you live with them or to provide you work or otherwise give you economic support, you can include those letters in describing your release plan. Also consider supportive letters from family and community members who may be willing to provide intangible support, which is, very, very important for folks coming home. Religious leaders, community members who are looking forward to you returning to the community and believe that you have something positive to offer, who can explain the value of your presence if you're in recovery, somebody who's involved in keeping you sober, and what they're willing to provide and what they anticipate time-wise that they would need to provide in order to help you come home and stay healthy. If you're in recovery or you require other forms of medical care or support, for example, if you have mental health treatment that you're getting while you're incarcerated or medication, what the plan is to continue that support. And you can do that by identifying relevant groups or facilities or doctors and how you'll use them. Again, all bearing in mind that everything you put in can become a matter of public record. And so as Maggie put it, being mindful of sharing only what you're comfortable sharing, but also providing a release plan that is going to give a prosecutor comfort that you have a plan for coming home and being productive. Key points, once again, on the excessive sentence. Bear in mind, think about your application from the prosecutor's point of view. Why should we modify the sentence that was imposed on this person who admits their guilt? You need to give a compelling reason. That reason should be specific and personal to your life story. It should include all the people who are negatively impacted by your incarceration and will be positively impacted by your coming home, and also should explain why your sentence no longer serves the interest of justice. And we got into a lot more detail about all of those ways you might express that and other areas you might look at in part one. So again, please watch that if you haven't and look at the materials that we created for that. your documented record of rehabilitation is critical and needs to be well supported, and your plan needs to be clear, concrete, and well supported. So I don't see any questions in the Q&A. At this point, we've answered a number of them. We can't provide legal advice and we can't answer case-specific questions. But if you do have questions, you can type them in now. I know that we have gone long, but we were trying to cover a lot of information. Again, you have a PDF of this presentation. This will be posted on OJRC's 819 website. So I'll stop talking for a minute, and if anybody wants to put a question in, please go ahead and do so. Otherwise, feel free to follow up with us via email if you have additional questions. And thank you all for attending. All right, I don't see any questions coming in. So we're going to close out. Thank you. This recording will be put up on the OJRC website and also on YouTube. So thank you again for attending. Thank you very much to Maggie and Kenneth, to OJRC, and Don't Shoot Portland. Have a great night.